All right. Hello, everyone. Welcome back to talking about the Bill of Rights. I'm here with Terry Lucas and Mara Zonderman for our next episode, discussing the Sixth and Seventh Amendments. Before we kick this off, I'm going to give a shout out to all of the East End libraries as a thank you that are participating in this. We have the Westhampton Free Library, Amagansett, Cudgegong New Suffolk, East Hampton, Floyd Memorial, Hampton Bays, Mattatuck Laurel, New Suffolk, Quogue, Southold, Port Jefferson, Riverhead, and Shelter Island. And with that, I'm going to turn it over to Mara.
Okay. Hi, everybody. Welcome back. Um, I know we promised you the Sixth, Seventh, and Eighth Amendments today, but turns out there's actually a little more in there to talk about than we thought there was. So rather than trying to rush through it too much, we're going to do the Sixth and Seventh Amendments today, and then do the Eighth, Ninth, and Tenth when we reconvene in August. So we'll kick it off with the Sixth Amendment. Terry, tell us all about it.
Okay, so before we get started today, I realized when I was putting the history together of the Sixth Amendment that we often refer to common law rights of the English, and I realized that doesn't really mean anything to most people. What does common law mean? So I went back to the Widener University Law School website, and it has a pretty clear description of common law. So I'm going to share that with you. So when we keep repeating the common law throughout this, you're going to know what it means. It defines common law as a law that is derived from judicial decisions instead of from statutes or laws. Where civil law uses legislation designed to cover every eventuality, common law uses judicial interpretation to apply the written law to specific situations. So common law systems are adversarial instead of investigatory, and the judge moderates between two opposing parties rather than the judge running the trial. A key element of the common law system is its reliance on and use of precedents, or the fancy word that I love from law school, stare decisis. And I don't even think I said that right that time. A precedent is a history of judicial decisions that form the basis of evaluation for future cases. The judge presiding over a case determines which precedents are relevant and can apply them to that specific case. And common law is often referred to as case law because it relies on the detailed records of similar situations and statutes due to a lack of an official legal code that can be applied to everything in the world. It's not uncommon to see common law and case law used interchangeably because they often refer to the same legal system used by U.S. courts. So that's a little background on the word common law, which will be repeated a lot. Okay, so we're going to go to the sixth. And I will read it to you. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. So like some of the other amendments we've talked about, we're going to break this up into pieces because this is kind of a big mouthful. So just as an aside, the next two amendments that we're talking about, the sixth and the seventh, are focused on the rights of people being accused of wrongdoing. The framers of the Constitution included these amendments because there was always that concern about the possibility of a strong government exercising its power to take advantage of citizens. So if we can go to slide number 4, I think it is, because we're going back in history again. Here we go. So we're looking at the history of the Sixth Amendment, which leads us back to the Assize of Clarendon. And those of you who are with us last time, we talked about this a little bit. The Assize set forth a procedure to provide for justice in a timely manner when the alleged wrongdoing happened in a place not scheduled to host a judge for some time. So, often in those days, a judge would be on a circuit and they would be able to, they'd have to wait to hold court and to seek justice. So in the next slide, in 1215, again, our favorite place, the Magna Carta, there was language reading, We shall not deny or delay justice and right, neither the end, which is justice, nor the mean, whereby we may attain to the end, and that is the law. So again, we had a little bit about a speedy trial there. And then much later, Sir Edward Coke, who was discussed in our Fifth Amendment talk, wrote on his Institutes that speed was one of the essential qualities of justice. And again, Coke was esteemed and read by the founding fathers as they were forming the Constitution. So in the next slide, in the early stages of the Revolution, the Continental Congress asked states to all write new constitutions. And so George Mason of Virginia looked to the Magna Carta in writing the Virginia Declaration of Rights. And that Declaration of Rights includes a speedy trial guarantee. And almost 14 years later, James Madison included the same guarantee in the Bill of Rights, and with very little change. So why are we providing this right? The framers were looking to prevent extended incarceration of people who were accused while waiting for trial. Also, at that point, that if you were jailed, it ruined your reputation, which could hurt your life and your livelihood. And finally, in any court case, memories fade, witnesses go missing. You need to have your speedy trial so that you don't lose the evidence and the information that you need to present in order to protect yourself. So with that, I'm going to turn it over to Mara.
Okay, so within this first clause of the Sixth Amendment, there are actually two bits: the right to a speedy trial and the right to a public trial. Looking at the right to a speedy trial first, the first question is, well, when does the clock start, so to speak? And the court has said that time is measured from an arrest or formal charge and runs through to a conviction or plea agreement, but does not extend if there's a delay in sentencing. It's from when the government becomes an accuser to when the evidentiary part of the case essentially is over. And the court has said in this 1972 case, a defendant's constitutional right to a speedy trial cannot be established by any inflexible rule, but can be determined only on an ad hoc balancing basis in which the conduct of the prosecution and that of the defendant are weighed. In other words, we're not going to give you specific time frames, but we're going to look at various factors. So in this case, Barker v. Wingo, Barker was arrested for murder, but his trial was delayed for more than 5 years. The prosecution was granted several continuances while Barker's accomplice was tried, so that the accomplice's conviction could be used in Barker's trial. Then, once that was completed, there were more continuances because a key prosecution witness was ill. But Barker, his lawyer, did not object to any of these continuances until about 3.5 years into this process, and 11 individual continuances. So then they said, we have to throw this all out because his right to a speedy trial was denied. And the court said that there were several factors that they should be looking at. The length of the delay, in this case, fairly lengthy, but also the reason for the delay, which essentially is a question of good faith. And it can go on either side. It can go to the prosecution or to the defense. Typically, since the defendant is the one who would be saying my right was denied, the court will look and see if the prosecution had a good reason for delaying the case, and wasn't just doing it to drag things along. Then whether and to what extent the defendant asserted their right to a speedy trial. So again, Barker let these continuances go for 3.5 years, 11 separate times before he raised any objection. And then lastly, whether there was any prejudice to the defendant as a result of the delay. And prejudice in this case refers to whether or how much the delay changed the likelihood of the outcome in favor of the prosecution. In this case, none of Barker's witnesses died. There didn't seem to be any evidence of failure of memory. So the court found that there was very little prejudice as a result of the delay. But again, the court specifically declined to say how long is too long, despite the fact that the government asked them to. So 2 years later, in 1974, Congress passed the Speedy Trial Act, of 1974, which basically sets out specific timeframes in which specific parts of federal prosecutions must be conducted. And most states do have similar laws for state prosecutions. And I'm not going to go through what any of those timeframes are because it's all, if it's this kind of case on the second Tuesday of the month that doesn't end with an R, then it's this long. It's that kind of thing.
Yeah.
I know at least one person who's listening today will recognize that, it might as well be the rules of FISBIN. So, but there are rules in place at the federal level. The rules on the state level will be different from state to state. But the court said, to make such rules is legislative, and we are the court. We cannot act legislatively. So the legislature just said, okay, we can, and they did. And it's one of those instances where the separation of powers worked pretty well. So moving on to what constitutes a public trial. In 1948, the court summed up a few cases that had been going on before that to say that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and to the importance of their function. Essentially, this whole trial court system doesn't work if nobody's watching. So who can assert a Sixth Amendment right? Only the defendant in a case can assert the Sixth Amendment right to a public trial. The court has said members of the public do not have an enforceable right to a public trial that can be asserted independently of the parties to a litigation. However, members of the public or the press can challenge their exclusion from a criminal trial under the First Amendment, under freedom of the press, freedom of assembly. And it turns out that the test that the court will use to evaluate whether the closing of a trial is valid is the same, whether it's the defendant challenging it under the Sixth Amendment or the public or the press challenging it under the First Amendment. The factors they look at are whether the party seeking to close the hearing has an overriding interest that is likely to be prejudiced. Overriding interests favoring closure probably do not include preventing risks inherent to all open trials, such as the risk that a jury might overhear a prejudicial comment, unless there is a specific threat or incident that aggravates a risk in a particular case, national security, public safety, or a victim's serious privacy interest. So you will see cases involving minors typically will be closed because minors have additional privacy interests over adults. The closure must be no broader than necessary to protect that interest, whatever that overriding interest is. Courts must narrowly tailor any closure of proceedings to the specific subset of the attending public and the specific portion of the proceedings that gives rise to the overriding interest in closure. So, for example, if it's a particular privacy interest, okay, we'll clear it while this particular witness testifies because nobody else's testimony is going to touch this particular privacy right. And lastly, the trial court must consider reasonable alternatives to closing the proceeding, even if the parties themselves don't put forward any alternatives. This is a very interesting case where there's a bit of an onus placed on the judge. If you're going to grant this, then even if the parties haven't laid out possible alternatives, you, the judge, have to demonstrate that you have thought of them, and there's a reason we can't go with any of those alternatives. And it just a note that this applies not only to the criminal trials themselves, but to at least two types of pretrial hearings, including motions to suppress evidence and the voir dire of juries or jury selection process. One thing that the court has actually never had to rule on is whether the right to a public trial includes sentencing hearings. So there is jurisprudence yet to be done, but the important thing to remember about a public trial is that it's not an absolute 100% right, but the court will err very heavily on the favor of keeping trials open to the public and to the press. So with that, we will move to the next clause.
And the next clause is about the, let's see, I have to go back and read it again here. Let's see. An impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. So, impartial juries. Prior to the Revolution, the colonies had very varied practices regarding jury trials. And when crafting the Sixth Amendment, the founders had to walk the line between putting in too strict of procedure and still protecting essential rights. So again, they look to their rights as Englishmen under common law, which was well settled with respect to jury trials at that time. So most colonial charters set out a right to a trial by jury, and all 13 state constitutions incorporated that right. So leading up to the Revolution, Great Britain took away the right to trial by jury, which went against their own 1689 Bill of Rights. The 1765 Stamp Act required those who violated the act to appear in admiralty courts, which were really meant for crimes upon the sea. And they had no juries. So they were being denied their right to a jury trial. And even earlier, Parliament had passed the Intolerable Acts of 1774. And under these acts, the use of colonial juries and those who could serve on those juries was really limited. So royal judges would control the jury selection, and they would seat juries which were completely composed of those who supported the king's laws. So the framers had a bad experience, so they felt very strongly that that members of a jury should be impartial to avoid cases being decided on biases, either for or against any of the parties, but instead on the evidence presented at trial. And this was driven by the experience of royal interference with the juries, as stated before. So in addition, the requirement that jury was supposed to be drawn locally was meant to guard against that interference. And so that's with the Sixth Amendment, we're going to find a lot of the clauses in the Sixth Amendment came from the fact that these were considered just essential rights. Then they were just part of the law. And so they weren't really discussed or debated much when they were debating the amendments. So that will take you to Mara to tell you a little bit more about impartial juries. You're on mute, Laura.
Okay. The impartial jury. So very basic. The right to a jury applies whenever the accused faces more than 6 months imprisonment. And it applies to any fact that would affect the permissible range of sentencing options. So it's a pretty low bar, but just so you know that not every criminal charge does come with the right to an impartial jury, but most of them. But what makes a jury impartial? What constitutes an impartial jury? The first thing is that it can be as few as 6 people, although most states do require the traditional 12. And it has to be, it has to be a representative cross-section of the community. Leading to the next question, what does that mean? The first thing it means is that this requirement that it be a fair cross-section of the community only applies to the community from which potential jurors are pulled. Because the court recognizes they say the practical impossibility of providing each criminal defendant with a truly representative jury. So if you've ever been called for jury duty, you go into a big room and there's 100 and 150 other people, however many, potential jurors. It is that group that needs to be a fair cross-section of the community, not the specific jury that is pulled from that group, but that larger group. There are instances where potential jurors are struck down during voir dire, again, jury selection. And under the Sixth Amendment, the court has said both sides have a right to strike jurors under however the law puts it, however many times, for whatever reason they want. But the Equal Protection Clause might become involved if it seems that jurors are being struck on the basis of race or some other protected class. So we're not talking about that, but I don't want you to think that, everything you've heard about, bias on juries and all this is completely wrong. It's just a completely different part. And Terry and I could go for days about that. There's so much to cover in the Equal Protection Clause. So that's all I'm going to say about that for now. So we're going back to the potential jurors. And in a 1979 case, the court laid out the factors that they are going to look at to see whether a particular group is being excluded from potentially serving as jurors. First, the group alleged to be excluded is a distinctive group in the community, so identifiable in some cohesive way, whether it's gender, religion, race, take your pick. That the representation of this group is not fair and reasonable in relation to the number of such persons in the community. If your community is 10% whatever, your jury pool needs to be 10% whatever. And if it's not, the court will want to know the reason why. And whether the underrepresentation is due to systematic exclusion of the group in the jury selection process. So what that makes one think of is if your jury pool, as is often the case, is pulled from your voter rolls, which is actually less the case now, but back in the day, but your voter rolls have literacy tests attached to them, specifically to exclude certain groups of people, then that is not allowed. That is, you're not getting a fair cross-section of the community. Certain groups are being specifically excluded. If the defendant is able to prove those three things, the burden shifts to the government to prove that there is a significant state interest that is manifestly and primarily advanced by those aspects of the jury selection process, such as exemption criteria, that result in the disproportionate exclusion of a distinctive group. So the burden is first on the defendant to prove that the group is being excluded and meets these three criteria, and then the government has to prove that it has a really, really good reason for excluding the group. And the court has, like I said, under the Equal Protection Clause, used it to eliminate lots of different kinds of exclusions based on race. But in Sixth Amendment jurisprudence, the court has struck down, for example, state selection systems granting women an automatic exemption from jury service upon request. So women would just have to say, I don't want to be included even as a potential juror, and they were out. And sort of the obverse of that, a selection system under which no woman would be called for jury duty unless she had previously filed a written declaration of her desire to be subject to service. So you would have to hand them a piece of paper that says, I want to be on a jury. The court found both of those to exclude a particular group. under the Sixth Amendment. The last thing about an impartial jury is this question of unanimity. We all now think, oh, your jury has to be unanimous. If it's not unanimous, you have a hung jury, a mistrial. That was not always the case. In 2020, so
Oh,
not very recently, in fact, the court overruled a precedent from the 70s, and incorporated the unanimity rule against the states. So there had been a rule at the federal level, but not in all of the states. And it wasn't until 2020 that the court said, no, state criminal juries also have to be unanimous. But they said that that decision did not apply retroactively. So if you had been convicted in a state criminal trial by a non-unanimous jury, too bad for you.
yeah.
Until now. Now you're good. And so the next clause.
It's all about timing, isn't it? Let's
Yeah.
see. Let's see. Okay, so by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of accusation. So that's our next clause, informed of the nature and cause of accusation. So the right to be informed of charges brought against an accused comes from English common law that actually predates the Magna Carta, but we still had to have a picture of the Magna Carta in here. This right is also consistent with Chapter 39 of the Magna Carta, which stated that a person could not be imprisoned without specific accusation in an indictment or otherwise in accordance with common law. So around 1351, Parliament enacted a statute that provided the king could not proceed against a free citizen without a specific accusation brought in accord with common law. In 1418, under King Henry V, a law was passed stating that indictments had to name the identity of the accused, the town and county, as well as the time and place of offense. It also said that the indictment must also be set forth with clearness and certainty. And in some crimes, particular words of art must be used. So there was specific language that you had to use when you were accusing someone, or it wouldn't be valid. Then in 1533, Parliament guaranteed that people could not be interrogated unless the government provided a substantiated formal accusation. So the right to be informed, was very well settled in common law. So the colonists expected to be accorded the common law rights of their fellow Englishmen. And I believe in most of the colonial charters, that was something that was stated. But when the rights were compromised, it was one of these issues which led to the revolution. If we have the next slide. So the Virginia Declaration of Rights in 1776 was one of the documents that was really used as a model for the Constitution. And it included language that said, a man has a right to demand the cause and nature of his accusation. So when the Constitution was being reviewed by states for ratification, several states were not happy. We had our anti-federalists that were not happy about the Constitution being ratified, and brought up the idea again that an amendment had to be passed that included, that set forth the right to be informed of any details of a crime a person was accused of. And during the first Congress, James Madison of Virginia drafted this clause of the amendment. And the text he submitted on June 8th, 1789 was identical to the language in the Sixth Amendment. And the version of this part of the amendment was adopted by the House and Senate without any comment. It was just it sounds like it was taken for granted. So with that, we'll turn it over to Miss Mara again.
And before we talk about this, you may have noticed that as we were talking about speedy and public trial, there was a whole second part to that clause that we did not address. An impartial jury of the state and district wherein the crime shall have been committed.
Right.
And my co-counsel over here reminds me of a theoretical case that highlights this particular clause. So trials, it involves a theoretical crime that is committed in Yellowstone National Park, which, as you may know, encompasses parts of 3 individual states, Idaho, Wyoming, and Montana. Thank you. I've even been to that part. Okay. So the theoretical crime is committed in the Idaho portion. Now, normally, trials of crimes that take place in Yellowstone, and they are there, and they do actually have a court, which of course we visited when we were there. They're usually held in the federal courthouse in Cheyenne. Sorry? Wyoming. But because of the Sixth Amendment, charges for a crime alleged to have been committed in the area of the park in Idaho would have to be tried before a jury consisting entirely of residents of that area, but there aren't any. So nobody lives in the federal area, because it's a national park, that is Idaho. So for this theoretical crime, no jury could be impaneled because the Sixth Amendment could not be satisfied as to a jury of the district. So just a little, this is how law students think, right? But we'll go back to the being informed of the nature and cause of the accusation. And the court said some time ago, it is elementary that an indictment, in order to be good under the federal constitution and laws, shall advise the accused of the nature and cause of the accusation against him, in order that he may meet the accusation and prepare for his trial, and that after judgment, he may be able to plead the record and judgment in bar of further prosecution for the same offense. In other words, you can't defend yourself if you don't know what you're defending yourself against. And that includes being able to appeal a conviction. If you're convicted, you need to know what you're convicted for, so that you can appeal. And since 1913, the court really hasn't had too much else to say about it. So we will move speedily along
Okay.
to the question of witnesses.
So the next clause reads, to be confronted with witnesses against him. So you have the right to be confronted with witnesses against him. So this clause is called the confrontation clause, which I like. The essential elements of the confrontation right requires that the accused have the opportunity to cross-examine the witness, that the witness take an oath to tell the truth, and that the jury be able to observe the witness's demeanor. And once again, this clause was included in the Sixth Amendment and passed by Congress with no floor debate, no discussion. But we'll talk a little bit about the history and why that came about. There's some debate if the right came to the framers through English common law, because in England in the 1600s, a defendant's demand to confront witnesses was rarely granted, and out-of-court statements were often used as evidence at trial. So this is, we have Sir Walter Raleigh here. His trial in 1603 is often cited. Raleigh was accused of high treason, and he was kept in the Tower of London. At the trial, one of the most damaging pieces of evidence was the confession of Lord Cobham, and he was supposedly his co-conspirator. Raleigh protested against that confession, saying, "But it is strange to see how you press me still with my Lord Cobham, and yet will not produce him. Let Cobham be here. Let him speak it. Call my accused before my face." So that's kind of the famous trial setting the right to actually see the people who are accusing you. So how did this end up in the 16th Amendment? And it's really believed that all the abuses by the crown in the 16th century and the unfairness of the king towards the colonists made them realize that they really had to state the law, state what they wanted, state that they needed to have certain protections. Even if it wasn't entirely clear back home, it was going to be clear here. So that is the history. What does Mara have to say?
Mara got her slides a little bit out of order, so bear with me for just a
Okay.
second. So the confrontation clause, I had them in alternate orders in my notes. So as Terry said, there are 3 fundamental purposes that the confrontation clause was meant to serve. This is the court put this down as far back as 1895. to ensure that witnesses would testify under oath and understand the serious nature of the trial process, to allow the accused to cross-examine witnesses who testify against him or her, and to allow jurors to assess the credibility of a witness by observing that witness's behavior. And the court in the past 130 years since that decision has mainly focused on this question of hearsay, which is defined as a statement, either a verbal assertion or nonverbal assertive conduct, other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Basically, the court says if someone is going to come and accuse you of a crime or proffer testimony that you have committed a crime, they need to do it openly and to your face, as Terry said. And it sort of is exactly what it seems. There are, of course, exceptions. When you take evidence in law school, the hearsay exceptions go on for days. But the general idea is that if the witness is able, physically, mentally, however you may be, they have to be present in court. Otherwise, the defendant's Sixth Amendment right to confront witnesses has been abridged. Go back now to compulsory process, right?
Right.
Okay.
So I just put this in here because we talked a lot about the 1689 Bill of Rights, and I love this picture of the co-rulers, William III and Mary II, accepting the 1689 Bill of Rights, just to look at the looks on their faces. They were not happy giving up the power. And so the freemen had a fight on their hands, but it was signed. So the clause reads, to have compulsory process for obtaining witnesses in his favor. So at the time of the Bill of Rights, the right of a defendant to bring witnesses was a new thing. It wasn't until the 18th century that the defendant even gained that right. Before that time, in the 16th century, the prosecution could present a full case with counsel, witnesses, and other testimony gained under oath. The defendant had no right to gather his own evidence or compel witnesses to come in person to testify. And he could make a testimony, but because it was unsworn, because they would not do it under oath, it lacked weight and it wasn't taken very seriously. So you were really, once you were accused, you were really in a bad position. So in the late 1500s, early 1600s, Parliament enacted some laws giving defendants rights in limited cases to present witnesses in their favor. And by the mid-17th century, this was pretty commonplace. But the witnesses remained unsworn. Again, if you have a testimony that is not under oath in that time, and even in this time, it was not taken as seriously. It's just you could say whatever you wanted to say if you did not swear. An oath was taken seriously. And the courts at that time did not have the right to subpoena witnesses. So you have to make sure, those witnesses would come because there was no power that would force them to come. So the next slide. Actually, I think that was this one. The British Bill of Rights in 1689 and several statutes passed by the Parliament in the following year incorporated a subpoena power in some cases. And it was granted in more instances. It became part of the common law, and this was studied by the founding fathers again. So after the Revolution, a number of states adopted some version of a compulsory process clause in their constitutions. And James Madison drafted the compulsory process clause based on the language of Blackstone, which again, the reference that they most went to. And Congress made only one non-substantive change, and the clause was not debated. And the clause passed easily and was not considered controversial in any way. It was just kind of a given. So that's compulsory.
So one of the earliest cases that involved the compulsory process clause came in 1807 when Aaron Burr was tried for treason. Yeah. And I don't know about anybody else's household, but in our household, anything involving Aaron Burr and Alexander Hamilton and that whole crew automatically piques our interest. So Aaron Burr was tried for treason on the basis of a letter from General James Wilkinson to President Jefferson, alleging that Burr was planning to dismember the states west of the Allegheny Mountains, invade Mexico, and establish a new government of which he would be the head. This falls under the category of things I don't remember learning in history class.
I don't either. Yeah.
So Chief Justice Marshall, who in this case was acting as the trial judge, because back in the day the Supreme Court justices would ride circuit, that's where we get the term circuit court, and act as trial judges. So he's still Chief Justice, but he's acting as the trial judge. Ruled that Burr's compulsory process rights entitled him to subpoena President Jefferson to produce the letter, which is noteworthy for a lot of reasons, but primarily because it established that the witnesses referred to wasn't limited just to people, but extended also to physical evidence. So you have a right to compel people to produce themselves or any evidence that they may have. Interestingly, Marshall also ruled that Burr could subpoena Jefferson himself. As he said, he found nothing in the Constitution that would justify any exceptions to the compulsory process clause. The president, after all, is not a king, but is governed by the laws and answerable to the courts. And we will not discuss any future jurisprudence on that matter. So compulsory process extends, is a very broad right that the court will enforce. And sometime after Aaron Burr was on trial, in 1967, the court said, in plain terms, the right to present a defense, the right to present the defendant's version of the facts, as well as the prosecution's, to the jury, so it may decide where the truth lies. Just as an accused has the right to confront the prosecution's witnesses for the purpose of challenging their testimony, he has the right to present his own witnesses to establish a defense. So it is a violation of the compulsory process clause if the state arbitrarily denies a defendant the right to put on the stand a witness who was capable of testifying to events that he had personally observed, we talked about hearsay before, and whose testimony would have been relevant and material to the defense. There are some exceptions. What else is new? Defense witnesses have to be identified in pretrial discovery. So just because you have this right doesn't mean you can spring a new witness on the prosecution. If you just found out about them, that's one thing. But if you know, you have to tell your opposing counsel about this witness. And if you don't, you may be seen to have waived your right. And there's also the question of whether witnesses who have been deported, whether the government is in that case arbitrarily denying the defendant the right to compel their witnesses. And the court says that on the face of it, a defendant cannot establish a violation of his constitutional right to compulsory process merely by showing that deportation of potential witnesses deprived him of their testimony, but has to show that plausibly their testimony would have been both material and favorable to his defense. So it's not just we want to have this person testify, it's that this person was basically going to make a difference. Lastly, the compulsory process clause has also been interpreted to guarantee defendants the right to testify in their own defense if they wish. So if you want to waive your Fifth Amendment rights under the Sixth Amendment, the court cannot say that you do not have the right to testify for yourself, which will bring us to the assistance of counsel.
So the final clause is, and to have the assistance of counsel for his defense. So under the Magna Carta, we're always going back to our Magna Carta, representation by counsel was actually prohibited for felonies, but it was allowed for misdemeanors. And this continued through the time of the Tudors in England from 1485 to 1603. This was also the time of the Star Chamber, which we discussed at our last session, that really had a strong effect on changing the common law to give more rights to the common man. So when we got to the colonies, Rhode Island was the first to specifically provide that there was a right to counsel. And in 1660, Rhode Island passed a law saying, where it doth appear that any person may on good ground or through malice and envy be indicted and accused for matters criminal, wherein that person is so accused may be innocent and yet may not be accomplished with so much wisdom and knowledge of the law as to plead his own innocence. Be it therefore enacted by this court the lawful privilege of any person that is indicted to procure an attorney to plead any point of law that may make for the clearing of his innocence, which is kind of a wordy way of saying you get to have a lawyer. Next slide. After the Revolution, a number of states included this right to counsel in their state constitutions. And additionally, the Federal Criminal Justice Act of 1790 provided every person who is indicted of treason or other capital crime shall be allowed to make his full defense by counsel learned in the law, and the court before which he is tried, or some judge thereof, shall immediately upon his request assign to him such counsel not exceeding 2, as he may desire, and they shall have free access to him at all reasonable hours. So the principal difficulty in determining the original understanding of all of the Sixth Amendment is that the framers adopted James Madison's draft, unlike other Bill of Rights guarantees, almost without debate and largely as proposed. And this Sixth Amendment clause was non-controversial again, and because its principles were already accepted. So I'll let Mara talk a little bit about assistance of counsel.
So, since the beginning, the court has been steadily broadening the types of cases that the Sixth Amendment applies to in terms of assistance of counsel. One of the first times they explored this question in 1932, they said the Sixth Amendment only guarantees assistance of counsel in capital federal cases. So in other words, federal cases with the potential for the death penalty. Otherwise, there was no right to assistance of counsel. You obviously could have it, but you didn't have a right to it. In 1938, they extended that to all federal cases, criminal cases, no matter what the potential punishment was. In 1963, they extended that to all federal and state felony cases. And then in 1979, they extended that to any case that might result in a jail term at the state or federal level. So we've gone from federal capital cases only to all federal cases to all felony cases to essentially all cases, felony, misdemeanor, federal, state, if there is the potential for a jail term to be established. And then in 2002, they went even further to include any case that might result in probation or a suspended sentence, thinking that if you're on probation and you violate your probation, chances are you're going to be going to jail, which means if that's a possibility, you should have had your Sixth Amendment rights from the very beginning. So they've been building it up ever more. And it's interesting because the right to counsel does not have to be affirmatively asserted by the defendant. An appeals court can find an error if the defendant didn't have counsel, even if they didn't specifically ask for it. So again, it puts the onus on the court itself to make sure that this right is being protected, even if the defendant is not taking that step for themselves. And of course, the right to counsel can be waived, but only as to the intelligent choice of the defendant as determined by the trial judge. You have, of course, heard of people going to court and representing themselves pro se, but we all know about the man who is his own lawyer and what kind of client he has, or she, or they. But you do have the right, but again, it is incumbent upon the trial judge to make sure that you understand what you're doing, basically. You understand the intricacies of the case, and the court can assign you a counsel even if you don't want one, in the interests of justice. the so in 1984, this goes back to the same thing that Terry has been saying also. All of these are based around the idea that you can't even pretend to have justice without all of these elements.
Mm.
The right to counsel is the right to effective counsel, right? That's the other part of this, effective counsel. And the benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. And the court looks at two prongs for that. The error prong, which asks the question of whether counsel's performance is deficient under the circumstances, which basically, was the lawyer arguing as well as your average lawyer of the time and place? And then the prejudice prong, whether the lawyer's supposed subpar conduct affected with some reasonable probability the trial's outcome. We call this a but-for causation. But for counsel's unprofessional errors, the results of the proceeding would have been different. It's a very, very high bar to prove that your counsel was ineffective. It goes beyond, they didn't make such and such argument. It's a really high bar. But the court does recognize that you can't just have any old whoever up there as your counsel. There has to be at least the bare minimum of effectiveness of counsel. And one note before we close out the Sixth Amendment altogether is, and this was interesting in light of the question that was asked last time about how we justify these ICE roundups with all these rights that we're told we have. Deportation proceedings are generally not considered criminal prosecutions under the Sixth Amendment. So that doesn't wholly answer the question, due process should still apply. We agree on that. But if I had to guess when some of this starts coming to court, they're going to be looking at the Sixth Amendment to say, no, we don't consider deportation proceedings to be included. So stay tuned. But I just thought that was an interesting note.
It is interesting.
Yeah. Now, before we move on to the Seventh Amendment, I will note that it is 6:53. So I'm awfully glad that we put the Eighth Amendment off to the time. The Seventh Amendment isn't too long, but do we want to move that and just move into questions about the Sixth Amendment now? And
Yeah, let's do the questions about the Sixth Amendment, and then we may have to just throw an extra one of these things in there somewhere so we can get through the Seventh and Eighth. But
we might. I have a feeling that we can do 7, 8, 9, and 10 all in one, but we thought we could do 6, 7, and 8 all in one. So
yeah, so who knows? But yeah, let's just get the question. I think we have one question.
But before we do that, I do want to just give our wrap up.
Oh, that's right.
For those of you who may have missed our first couple of sessions, we are going to be live and in person at Rogers Memorial Library at the beginning of July for 2 separate sessions. We'll do sort of the introduction, and then we're just going to do the First Amendment. So if you missed that, or you want to come again, or whatever it may be, and you are able to get to Rogers, do please join us. Contact that library to register for that program. And then other than that, we're gonna skip July and move most of the way through August, where we will apparently attempt to do the 7th, 8th, 9th, and 10th Amendments, and then we will do our wrap up in September. So,
okay.
Yes.
Or prepare for kind of a longer one in August because you get a break in July. How about that?
Yeah, maybe.
We'll see.
We'll see. So there is the question, Regina asks, doesn't the accused have the right to have a peer jury if he or she is from an area different from the prospective jurors and have nothing in common with the prospective jurors? That's a really good question. Because we hear that you have the right to a jury of your peers.
Peers, yeah.
But as you may have noticed, as we were talking about that, that's not what the amendment actually says. You have a right to a jury made up of a fair cross-section of people in the district where the crime was committed. which is having seen your question, that's part of why I talked about this theoretical crime in the corner of Idaho that's Yellowstone National Park, because if you go somewhere else and commit a crime, that's on you, right? You don't have the right to say, well, these people aren't like my community. And unfortunately, it of course also applies even if you did not commit a crime but are accused of a crime in some far-flung jurisdiction. It is not, there's no guarantee that the jury will look like you. But the jury will have to look like the community that it comes from. But that's a really good question. Thank you, Regina.
So be careful where you commit your crimes.
Right.
Make sure you think the people there are gonna be for you. So yeah,
right.
Little bad advice. So anyways.
Are there any other questions?
I'm not seeing any more questions come in. Q&A seems quiet.
So
okay.
Once again, Terry, either you and I have done an astounding job at explaining all of this, or everyone fell asleep.
Well,
or we utterly confuse them and they don't even know what it is.
Yeah. But you can always get a hold of us if you need us.
Yes, absolutely.
So Westhampton for Mara, Shelter Island for me. And with that.
And yep, you guys will be able to find all of the old ones on YouTube in case you don't have questions because you're not caught up. So no worries. Link will go out with the recordings as well when this one's recorded and edited by me next week.
Thank you, Sarah.
But wait, do we have another question that just came in?
We do. It just popped it. Oh, no, thank you so much from Kachog. We love that.
You're very welcome. Thank you for coming.
Thanks, everyone. Right. Have a good, happy 4th. Okay, say the word,
semiquincentennial.
Happy semiquincentennial.
Yes.
Bye.
All right. Bye.